Hello, welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we look at what happens in a fall-down personal injury case. So, typically, after someone signs the retainer agreement with the attorney will send a notice of injury letter to the defendant property owner. How do you find out who the property owner is? Well, there's tax records. If someone's injured at a store, we also send it to the store. Depends upon where someone is injured. But so the letter should say name of the injured person, the date of the accident, place of the accident, that we represent the person and a claim against the insurance company and them. We also ask them to provide us with the names of their insurance companies and provide us with a declaration sheet. The attorney will also send, if they know who the insurance company is, a letter to the person's insurance company with also a copy of the incident report, because sometimes people don't report the accidents to their insurance companies. What happens next? Let's see. Two is the investigation and obtaining of detailed records. So the attorney must complete the investigation, setting up a file. So we will need the client should provide us with copies of any bills, any medical records, anything that they have in connection with the accident, wage losses, etc. Once the person typically is on the tail end of finishing treatment or finished treatment, then as we go along, we try to keep sending documents to the insurance company for the negligent person, build up their file, and then we provide them with any medical records, any reports we have. If there's income loss, proof of time off of work, other damages, pain and suffering. Let's see, thereafter, the attorney and the insurance company people will try to see if they can work out a settlement. Many cases settle without a lawsuit, but sometimes insurance companies won't pay or lowball. So if they don't do that, next step, file the complaint in the Superior Court of New Jersey. So your attorney will prepare what's called a complaint and a case information statement. They got to file it online through the e-court system, and then the defendant through the insurance company has to file an answer. The formal complaint will list the parties involved, the court's jurisdiction, the legal basis, facts and evidence to support the claims, and a demand for how much you're seeking. And what you also want to do is make sure that the complaint is properly served, because there's this thing called the Statute of Limitations, and the complaint has to be served upon the proper entity. So serving the wrong entity is not sufficient. So we also tell people don't wait till the last minute to decide to meet with an attorney. The time to do it is right away. After the complaint is filed, then there's the discovery process. Let's see, there's written interrogatories answered by both sides, then the taking of depositions, medical examination sometimes, and then after that's done, the parties see if they can try to settle. If they don't settle, then there's an arbitration set up by the court. You go to the courthouse, there's an arbitration, the arbitrator throws out a figure, the parties try to settle. If the parties can't settle, then it goes to trial. Simple as that. So the client always has the decision whether or not to accept or reject an offer. They can't be forced to take an offer, but some people just don't want to go to court. For other information on personal injury cases, visit website njlaws.com, njlaws.com, and for representation, contact Kenneth Vercammen's office in Edison at 732-572-0500.